What if the very system that's, designed to save you from a legal nightmare is actually a trap?
Right, it's a pretty unsettling thought.
I mean, imagine for a second that you're locked in a legal dispute. Maybe it's a clash with your employer over unpaid wages, or you're going up against some massive corporation because a product they sold you caused severe property damage.
Exactly, the kind of stressful situation no one wants to be in.
Yeah. And you finally drag yourself to the courthouse, and the judge lets down from the bench and offers what sounds like a total lifeline.
They suggest skipping the agonizing multi-year trial.
Right. They say, hey, head straight to alternative dispute resolution. Faster, cheaper, entirely private. You avoid the witness stand completely.
Which, on the surface, sounds like a massive win for you.
It really does. But today we're doing a deep dive into the underlying mechanics of that exact scenario. We're looking at the actual realities of alternative dispute resolution, which you usually hear abbreviated as ADR.
And we're pulling from some really fascinating source material on the paradox of efficiency in the judicial system.
Yeah, exactly. But before we get too deep, we need to draw a clear line between the different types of ADR because, well, they function very differently. The two big ones are mediation and arbitration.
That distinction is so critical. I mean, in mediation, you basically have a neutral third party who sits in the room just to facilitate a conversation.
Just to get people talking.
Right, exactly. They have zero authority to force a decision. Their only job is to help the two sides negotiate a voluntary settlement.
Okay, and arbitration, because that's the one you hear a lot about in contracts.
Right. Arbitration is a completely different mechanism. An arbitrator acts almost like a private judge.
Oh, so they actually make a ruling.
They do. You present evidence to them, and they hand down a binding ruling that you are legally required to follow. And usually there's absolutely no option for an appeal.
Wow. Okay. And the mission of our deep dive today is to unpack how the modern judicial system is just, increasingly relying on these private ADR mechanisms to clear out their massive case backlogs.
Because the courts are overwhelmed.
Right. And we're exploring this really counterintuitive reality that this relentless pursuit of administrative efficiency might actually be eroding your fundamental rights.
It's a huge shift.
It is. And honestly, when I first read this, I was super surprised. I always thought of mediation as this progressive, modern way to handle disputes. Like everyone sits in a circle and works it out peacefully. So this counter narrative is just deeply intriguing to me.
It's easy to see it that way, sure. It sounds friendly.
Right. And for you listening, whether you're clicking agree on a new software update or, signing an employment contract, this shift in the legal landscape affects you directly.
Absolutely. It's everywhere.
So let's start by looking at why the courts are pushing this so hard in the first place. When you examine the current state of the judicial branch, you just see a system that is fundamentally drowning.
Oh, civil courts in so many jurisdictions are completely underwater.
Yeah.
I mean, decades of underfunding combined with population growth.
And all that complex corporate litigation too, right?
Exactly.
Okay.
It's created these unprecedented backlogs. A standard civil trial can easily take 3 to 5 years just to get onto a judge's calendar.
3 to 5 years. That's insane.
It is. So courts are desperate for a release valve, and ADR provides a mechanism to divert cases away from the courtroom.
Which historically made sense, right? Like ADR was supposed to be this entirely optional, flexible alternative for parties who, wanted to preserve a business relationship rather than go to war in court.
That was the original design, voluntary and flexible.
But the reality today is that it's morphed from this optional alternative into a quasi-mandate. It's embedded directly into the judicial process.
Right. Courts are now routinely implementing structured programs that direct parties toward mediation or conciliation before a judge will even look at their file.
Which introduces this fascinating psychological dynamic for the person standing in that courtroom. I mean, think about it. If a judge, the person wearing the robe, the official who holds the ultimate power over your eventual trial, if they strongly encourage you to settle in mediation,
it stops feeling voluntary real fast.
Exactly. It feels a lot like when your boss drops by your desk at 4:55 p.m. on a Friday and suggests you might want to look over a report over the weekend.
That is a perfect analogy.
Right. Because sure, technically, they are just making a suggestion. You could say no. But the inherent power dynamic means you don't really feel like you have a choice.
Well, the weight of judicial endorsement completely alters the negotiating environment. A judge is a figure of immense authority.
Yeah, you don't want to make the judge mad.
Exactly. A mere suggestion to pursue mediation is frequently interpreted by a litigant as a strict directive.
Like an order.
Right. If a plaintiff declines mediation because they want their day in court, they often carry this fear that the judge will be irritated by their refusal.
And hold it against them during the actual trial.
Precisely. That subtle compulsion totally changes things.
Okay, let's unpack this for a second, though. If I settle purely out of a sense of obligation to the judge or fear of displeasing the court, can we really call that a voluntary settlement? The core ethical foundation of ADR is totally compromised.
It's a manufactured willingness to compromise.
Right. But let me push back on this premise just a little bit.
Sure, go ahead.
If courts are drowning in 5-year backlogs, isn't an imperfect, slightly coerced mediation still better than waiting half a decade for a perfect trial? I mean, at least the person gets some kind of resolution and can move on with their life.
That's the common defense. But that assumes the resolution achieved in that private room is actually equitable.
And it's not.
Well, when courts integrate ADR just to clear their dockets, they replace objective legal standards with that subtle compulsion we talked about. People start making concessions, not because the compromise is fair, but just to escape the pressure.
Just to make it end.
Exactly. The legitimacy of a settlement relies on a genuine willingness to compromise. When that's forced by institutional pressure, the process stops being an instrument of justice. It transforms into a purely administrative tool.
Wow. Okay, so if individuals are being quietly pressured into settling behind closed doors, we have to look at what happens when you combine that compulsion with a David and Goliath power dynamic.
Right, the asymmetry of power.
Because there's this deeply ingrained assumption that ADR involves two relatively equal parties hashing out their differences, right? Two neighbors arguing over a fence.
Which is incredibly rare in modern disputes. Consider the typical legal conflicts everyday people actually face.
Like what?
An individual employee challenging a multinational corporation, a consumer suing a well-funded manufacturer, or even a family law dispute where one partner holds complete control over the household finances.
Right, the power imbalance is staggering. It's like sitting down to play a game of high-stakes poker, but the corporation can see your cards, they have a team of statisticians feeding them probabilities, and they have an infinite stack of chips.
While you are playing with your rent money.
Exactly. But wait, isn't the mediator there to make sure things are fair? Like, aren't they supposed to level the playing field?
That's a huge misconception. That structural imbalance is exactly why the formal courtroom was designed the way it is in the first place. Traditionally, courts are the equalizers.
Okay, mechanically speaking, what does a judge do to equalize that poker game that a mediator doesn't do?
A judge applies strict rules of evidence. They oversee formal discovery.
Which means what, exactly?
It means they legally force the corporation to hand over internal documents and emails they would otherwise hide. A judge enforces procedural safeguards that protect the weaker party from being buried in bad faith legal maneuvers.
Oh, and a mediator doesn't do any of that.
No, a mediator is just a facilitator. Their primary objective is simply to help the parties reach an agreement so the conflict ends. They are not empowered to enforce legal fairness or correct a severe power imbalance.
So you strip away the rules of evidence, you strip away the judge's oversight, and you lock an individual in a private room with a corporate legal team. That is terrifying.
It is. Without those strict judicial safeguards, the economically vulnerable party will often just accept a highly unfavorable settlement simply because they run out of financial resources or emotional stamina to continue the fight.
Just to end the nightmare.
Exactly. And this really highlights a critical phrase from the text. Docket management tool.
Right. The system just wants fast numbers.
Yes. Judicial performance is frequently evaluated by case disposal rates, like how many files a judge can close in a fiscal year.
So the institution prioritizes the speed of the spreadsheet over the quality of the outcome. A settlement that leaves a vulnerable employee severely disadvantaged still counts as a win for the court's statistics.
It's efficient, sure, but it isn't justice.
Okay, let's look at the actual mechanics of the timeline and the costs. Because if the justification for pushing people into ADR is that it saves the listener time and money, we really need to verify if that's true. Spoiler alert, the sources say no.
Not at all. It's what the source calls the paradox of proceduralization.
Which means what?
Well, ADR was conceived as an escape from bureaucracy.
Right.
It was designed to bypass the red tape.
Right.
Instead, the legal system has simply institutionalized it, turning ADR into its own sprawling bureaucracy.
Here's where it gets really interesting to me. ADR was invented to avoid bureaucracy, but now it is a bureaucracy. Courts have created these mandatory pre-litigation conciliation requirements.
Yes, institutionalizing mediation centers.
Before you can even file a motion to have a judge hear your dispute, you're forced to attend mandatory mediation sessions. The text mentioned that you might hit an impasse in the first session, and then you're ordered to attend a second.
Or a third.
Right. It doesn't bypass the waiting room. It just adds 3 more waiting rooms you have to sit in before you reach the actual courthouse, which extends timelines rather than reducing them.
Exactly. The timeline extends and the financial barriers multiply. This is particularly severe in the realm of mandatory arbitration clauses.
Ah, yes. These are the paragraphs buried on like page 12 of the user agreement you just scroll past and click accept on just to use a piece of software or accept a job offer.
Everyone does it. But by clicking accept, you waive your right to a public trial. You are contractually forced into a private arbitration forum.
Which sounds fine until you look at the price tag.
Right. Public courts are subsidized by taxpayers to ensure citizens have access to the law. A standard filing fee might be a few $100s, but private arbitration requires you to essentially rent the legal system.
Rent the legal system. That is a wild way to put it.
But it's true. You must pay the arbitrator's hourly rate, and many arbitrators are retired judges or specialized corporate attorneys who charge hundreds of dollars per hour.
And that's on top of administrative charges and the cost of renting the venue or conference room where the arbitration actually takes place.
Right. So the upfront cost to simply initiate the arbitration can easily exceed thousands of dollars. For a worker trying to recover, say, $2,000 in stolen wages, the financial architecture of the arbitration system makes it mathematically impossible to seek justice.
The system itself acts as a barrier to entry. But wait, let's trace this all the way through. Let's say I jump through all these mandatory hoops, I pay the fees, I go to the private mediation, and against all odds, the corporation and I actually reach a settlement agreement.
Okay, a success story.
Right, we sign the paper. But what happens if 3 months later, the corporation just decides to ignore the agreement and stops paying me the settlement money? What mechanism actually forces them to comply?
That is the ultimate structural irony here. A private settlement is simply a contract.
Wait, really? Just a contract?
Just a contract. If a party violates that contract, a mediator has absolutely no enforcement power. An arbitrator cannot send law enforcement to seize corporate assets. To enforce the settlement, you must file a formal lawsuit for breach of contract.
You have got to be kidding me. You end up right back in the public court system you were trying to avoid in the first place.
You restart the litigation process from the beginning. Disputes over interpretation or compliance just force parties right back into court. The ADR requirement didn't bypass the court, it just added an extra incredibly expensive layer of friction.
That exhausted your resources before you inevitably ended up in front of a judge anyway?
Precisely.
Okay, so we've looked at the personal cost, but if all these individuals are draining their bank accounts and waiving their rights behind closed doors, what happens to the rest of society who doesn't even know this is going on?
That brings us to the macro perspective.
Right. We're transitioning from the personal cost to the societal cost. The sources introduced this concept known as the black box. If individual disputes are forced into private rooms, what happens to the public's understanding of the law?
It creates 2 massive societal harms. The first is a weaponization of confidentiality.
Now, privacy sounds nice on the surface, right?
Sure. In highly sensitive business disputes or family matters, privacy is a legitimate requirement. However, when applied to broad consumer or labor conflicts, repeated confidential settlements act as a shield for systemic issues.
Let's make this concrete. Imagine a massive car manufacturer discovers that the braking system in their newest SUV fails at highway speeds. People start getting into accidents.
A terrible scenario. If the traditional court system is used, every one of those injured drivers files a public lawsuit. The formal discovery process unearths the internal corporate memos proving the manufacturer knew about the defective brakes.
Right, and those documents enter the public record. Investigative journalists report on them. Federal regulatory agencies launch investigations. Everyone knows.
But if every single one of those drivers is bound by a mandatory arbitration clause,
they are forced into private, isolated hearings.
Exactly. The manufacturer settles with the first 10 injured drivers privately. As a condition of receiving their medical compensation, every driver is forced to sign a strict non-disclosure agreement. The internal memos regarding the defective brakes remain permanently sealed.
Oh, wow. So the 11th driver walks into a dealership and buys that exact same SUV completely blind, having absolutely no idea the vehicle is a death trap.
Because the legal system allowed the corporation to quietly purchase silence 10 times in a row.
That is chilling. Essentially, a corporation could commit the same misconduct 100 times, settle quietly 100 times, and the public would never know.
The mechanism of confidential settlement severs the feedback loop that society relies on to identify dangerous products, or predatory lending schemes, or widespread labor violations.
The public remains entirely unaware because the judicial system actively facilitates hiding it. Which brings us directly to the second massive societal consequence, the stagnation of legal precedent.
Right. If we connect this to the bigger picture, how does the law actually evolve if the cases never reach a judge?
It doesn't, right?
Exactly, it doesn't. Our legal framework operates on the common law system. Courts don't exist merely to resolve an isolated fight between two individuals. Appellate courts issue written, public rulings that establish binding interpretations of the law.
Judicial decisions that guide future conduct.
Exactly. They dictate exactly how a specific statute should be applied in the real world. But when millions of disputes are siphoned away from the public docket and settled privately, the development of jurisprudence slows down.
The courts are starved of the raw material they need to issue those authoritative rulings.
Right. And this is critically dangerous when dealing with emerging areas of law that are entirely unaddressed.
Like things like artificial intelligence using copyrighted material or gig economy workers fighting for labor protections.
Exactly. If every dispute between a gig worker and an algorithmic platform is resolved in a private arbitration room, the legal system never gets the opportunity to define what a worker's rights actually are in a digital economy.
The technology advances at lightning speed, but the jurisprudence freezes in time because the novel legal questions are never allowed to be publicly argued and ruled upon.
The system is essentially eating itself. We are trading the evolution of human rights for administrative efficiency.
Okay, so bringing it all together, how do we save the justice system from becoming entirely privatized and hidden while still utilizing the genuine benefits of ADR? Because mediation and arbitration are not inherently evil tools.
Right, they have a place. When two massive companies are fighting over a supply chain contract, a private arbitrator makes perfect sense.
Right. So how do we restructure this environment?
The system needs balance. Fixing the structure requires implementing rigorous mechanical safeguards. The primary correction must be restoring genuine voluntariness. The institutional practice of judicial coercion, where judges pressure parties to settle as a docket management strategy, must be strictly prohibited.
Yes, referrals must be genuinely voluntary. A referral to mediation has to be a true option, not a prerequisite for accessing your constitutional right to a trial.
Furthermore, judges need training to screen cases before allowing them to be diverted. We can't just rely on blanket administrative policies that send every civil filing to a mediation center. A judge must evaluate the core of the dispute.
Mechanically, what are they looking for during that screening process?
They must identify whether the case involves a fundamental constitutional right, an emerging area of law that requires new precedent, or a matter of profound public interest.
Matters of public interest shouldn't be settled privately.
Exactly. If an employee is alleging widespread, systemic racial discrimination across a multinational corporation, a judge must recognize that the public interest demands a transparent, on-the-record judicial process.
That case cannot be permitted to vanish into a confidential arbitration proceeding. The public has a right to the precedent that case would generate.
Right. Courts also need to reassert their role as the equalizer. We need judicial oversight to verify informed consent. If a case is sent to mediation, the court must ensure that vulnerable parties have access to legal representation during the mediation process itself.
Right, counteracting that severe asymmetry of facing a corporate legal team completely alone.
Yes, but the most vital mechanism for fixing the black box problem is transparency.
Right, how we handle the data. You can maintain the privacy of the individuals involved while completely destroying that corporate shield of secrecy.
It's all about publishing anonymized data from ADR centers to spot systemic trends. Institutional ADR centers and private arbitration firms should be legally mandated to publish aggregate statistics regarding their proceedings.
How does that actually work in practice?
Well, the center does not release the names of the plaintiffs or the exact dollar amounts of the medical settlements, which protects individual privacy.
Okay, makes sense.
However, they are required to publish the macro-level data, like how many claims were filed against a specific corporate entity, the broad category of the disputes, and the ratio of cases won by the corporation versus the consumer.
So a state labor board could look at a public database and clearly see that over the last 12 months, 500 separate private arbitrations were initiated against one specific logistics company regarding wage theft.
Exactly. It provides regulators, journalists, and the public with a mechanism to identify systemic abuse without violating the granular confidentiality of a specific settlement.
It forces the private system to interact with public accountability.
It does. Alternative dispute resolution is an incredibly powerful tool, but its function must be to complement adjudication, not replace it.
Yes, that is the central takeaway here. ADR should complement, not replace. A functional society requires the capacity to negotiate compromises, but justice requires reasoned decisions just as much as negotiated compromise.
We cannot sustain a civilization exclusively on private handshakes and non-disclosure agreements. The legitimacy of the judicial branch hinges on recognizing that justice is not just a metric of speed.
It really brings us right back to the beginning. You're standing in that courtroom, the judge points to the mediation room, and the pressure to take the quiet, hidden exit is immense. As you navigate the contracts you sign and the disputes you inevitably face, consider the true cost of that private room.
It's something everyone needs to be aware of.
Absolutely. And I want to leave you, our listener, with a final lingering question to mull over. If the future of our legal system prioritizes quiet compromises over public truths, how will everyday people ever know what their rights truly are? If every conflict from the workplace to the products we buy is settled in the shadows, does our collective sense of justice simply fade away?
Subscribe to Ambat Legal Insight and stay legally informed with clear, practical, and reliable breakdowns of the law. Follow our channel and activate the bell icon so you never miss important legal updates, case analyses, and expert insights that matter to every citizen. Support our mission of spreading legal awareness by liking, sharing, and commenting, because your one action can help thousands become more legally empowered. Join the ALI community today across YouTube, podcast, and social platforms and take a step toward understanding your rights, your laws, and your justice. Ambat Legal Insight, because law is for everyone.